Hi, everyone. Good evening. Carl Steinbeck here to talk about Commonwealth of Massachusetts versus Karen Reed. Today was day 29, Monday morning through the afternoon. We heard this case where it was an absolute disgusting abomination the way the state conducted their affairs before this judge who did her best to side with the Commonwealth. Once again, you might as well have a counter. The things that she does to bolster and prop up this sham prosecution case against Karen Reed. It's just unbelievable. You will never see a case, at least I've never seen a case. This is like multiple times over anything I've ever seen where judges not even trying to look fair on major important critical rulings. And so the benefit of this is, though, I can tell you, as much as this is so much bad for your health to watch, if you have any sense of justice and if injustice of something makes you upset and angry, I mean, this is a case I can't imagine getting you more riled up about because it's rampant, the abuse going on here. The Constitution is absolutely trashed in this so-called court of unlawfulness and lawlessness. So I mean, it's got to be. I've never said that about another court before. Okay, I've never said that. I never thought I'd say that about a court in America. But this is really so far above and beyond an extreme of what you'd ever see that I thought you'd ever see in an American court of law. But we're up here in Massachusetts, where the corruption has run for centuries, and so this is what the people are paying for with their super high taxes. No one's brought up what the judge makes, but we see the cops, they're making 230 to 322,000 a year, which is higher than most federal agencies ever pay their top people, even cabinet level folks. So this is what you get when people are above the law, and then they can go out there and hire somebody like Brennan because they don't think there's anybody enough in their office that has the kind of how should you say ability to hide the truth like Hank Brennan can, because all he's doing is defense mode, block, 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 keep out the truth, keep out the truth, and that's what a defense attorney does if they got a guilty client. So in this case, his client is guilty of covering up and railroading Karen Reed into a conviction. At least that's what they're trying to do. But I do believe that in the end of all this, we just got to sit back, look at the big picture. He's winning these little battles with his judge, but he's losing the war. Okay. The war is actually getting a conviction, and he has lost that. He's lost it a long time ago. If you look at my videos, I've said this has been game over many weeks ago. You cannot have this kind of shady dealings going on and hide the ball and this kind of like just terrible attitude and persona coming across just reeks of it's all about treating the jurors like they're a bunch of dumb clucks. Okay, that's what he's really doing. They're a bunch of dumb knuckle dragging fools that he can just act any way he wants, and whatever points he thinks he's making, these knuckle dragging idiots up there that's on the jury, they're just going to fall for whatever he says because he's a prosecutor, and the jury's just going to believe anything he says. Well, guess what, folks? I've never seen it happen this way. He is by far the worst presenting prosecutor I have ever seen. You could say defense attorney of any course I've ever seen, with a live trial that I've been there in person, anything I've seen on TV, YouTube, whatever. This is the worst performance I've ever seen from a prosecutor. And think about it, the guy is actually very calculating, strategic, and tactical about the way he goes about everything. Everything is very much thought out to the bottom line of how he's going to get this information out. Basically, his main job is not how to get information to the jury. His main goal, as we've seen here, is how to keep the truth out from the jury, because that's the only way he can get a conviction. He knows it. Like I said, a good prosecutor, if you're a good attorney, you know what you're doing. You can say, you know what? I got my witnesses. I got my evidence. I'm going to tee it up. I'm going to present it all. And guess what, defense? Throw everything you want against mine, witnesses and evidence on cross-examination. Try to block it. No matter what you do, the truth is going to come out to this jury. I don't care what witnesses or experts you present on your defense. I can slice them and dice them up where they're not going to have any credibility, and I'll be able to effectively argue with a position of power and strength and truth of why the prosecution has met its burden of proof. Okay, that's what you should be able to do if you're a good attorney. You could even take a case that's maybe not so easy to win, but if the bottom line is the defendant is in fact guilty, a seasoned, experienced attorney knows that they can present the case that way, and they will turn out with a conviction. But here you have so much of this trickery, hide the ball, block, just over and over again. And you got this judge that's just doing most everything she can to hardly ever overrule an objection. And she's basically like Morrissey. You might as well have Morrissey sitting up on the bench there. It's not even looking fair. So when the judge is doing that much to help the prosecutor who's trying to cover up the truth, hide the truth, and in essence, the judge is also a part of this cover up of the truth as well. So that's why I wrote in the title and the comments that this is really a part of the judge covering up the truth as well, as we'll see here, more efforts to block expert testimony. That just makes this thing such an open and shut case. My prediction, though, is the jury is so much in tune with this corrupt type process that they will return a not guilty verdict across the board within the first 4 to 6 hours. I think it'd be even quicker, probably less than 3 hours, 2 to 3 hours. Part of it, they're just going to be comparing notes and just be doing shock and awe comparisons on, hey, did you catch this, what Brennan was trying to do, and just be basically shaking their heads and just absolutely disgusted by what they had seen. And all these notes are furiously writing to compare. So I do think that it'll be less than a day ultimately if we give them a full day. And I really think it's a kind of thing where they're going to come back quick because they don't need to really deliberate this because the government has failed miserably. Keep in mind, we don't even have a medical expert, medical examiner that says that this vehicle struck John O'Keefe. Karen Reed's SUV struck John O'Keefe. So they're really just on, they're running on fumes right now. And so Hank is getting more and more desperate. I think the officer Barrows really made him realize and created a panic and paranoia in him that he's really about to lose this thing, and not lose it, but lose it big time. So with that, let me cover what happened today. Let me make sure the closed captions turned on. All right. So the motions happened from 20 minutes in from the first time we started coverage here on Boston's Channel 10. So about 20 minutes in is when it started. The motions, the Commonwealth motion to call witness on rebuttal was granted. There was an argument that Ms. Little had that said that the Commonwealth has already been on notice about dog bites and they wanted to limit Welcher's testimony to address new testing only. But so rebuttal is not supposed to be a chance to go and start your case in chief over again. It's supposed to be new stuff that was raised by the defense that you want to rebut. So it's not supposed to be the whole call all your same witnesses all over again. And so the other motion was regarding the testimony of Dr. Elizabeth Laposada. She's a doctor with also forensic pathology experience. She's done 3,000 autopsies on her own, another 7,000 either consulting or supervising. And the Commonwealth wants to exclude what they call the relevant photographs testimony, including that about the investigation. So she's going to be voir dire today. We'll get into that. And then there's a motion to limit Dr. Rentschler's testimony. He's the other expert from ARCA. And so I'm going to cover that as well. But first, let's go to, after all that transpired, let's go to the 58-minute mark. And we're going to see here the remaining testimony of Dr. Wolfe from ARCA.
Charles, I'll remind you, you're still under oath.
All right, good morning.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolfe, thank you for joining us again this morning. I'd like to draw your attention to a picture. May I approach, John?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes,
You were shown this photograph last week, is that right?
correct,
By Mr. Brennan, correct?
correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes,
Under questioning by Mr. Brennan?
yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from
True.
of the test dummy from the 29 mile per hour impact test.
And does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes,
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court corner.
Exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
yes,
Yeah, I noticed that design rhythm. I should have mentioned that. Thanks for bringing this to our attention. Interesting how the judge didn't say good morning, doctor, like the other doctors. But you know what? Let's go back. Let's look at this interaction again here. He never called her your honor or judge either. He's disgusted with her behavior.
Questions? Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain
Of course,
from
they're
doing any
talking to people,
independent research or investigation
doing
into
research.
this case?
because they know you guys are blocking it left and right.
Did anyone happen to see, hear, or read anything
They're
about
sick of
this
it.
case since we left here on Friday? Everyone said no or shook their heads. Okay, thank you. Can we have Dr. Wolfe, please?
Yeah, they're seeing through this, Sherry D. You can't be this outrageous.
Mr. Armand, you're still under oath.
All right, good morning.
Jury not pick up on it. Okay, look at her. Look at her. She. Let's see.
All right, Mr. Jackson, whenever you're ready.
Okay, look at her. Is she going to say anything to him? She's upset because he's sinking the government's case. She doesn't want to acknowledge him. Look, she looked up at him for a second.
Mr. Armand, you're still under oath.
All right, good morning.
Good morning.
Yep. Doesn't want to acknowledge his doctor status. That's nice. And you know what? He didn't acknowledge her as judge or your honor. So,
All
good
right,
job,
Mr.
Dr.
Jackson,
Wolfe.
whenever you're ready.
Thank you, Your Honor. Dr. Wolfe, thank you for joining us again this morning.
Can you imagine how he's been whipsawed coming up there multiple times? He had to go home this weekend, then he had to come back. So, in the kind of harassing and haranguing that's been going on with his family. So, what a disgrace this whole process is up there. An absolute disgrace.
I'd like to draw your attention to a picture.
Yeah.
May I approach you?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes,
You were shown this photograph last week, is that right?
correct,
By Mr. Brennan, correct?
correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes,
Under questioning by Mr. Brennan?
yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from of the test dummy from the 29 mile per hour impact test.
And does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes.
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court reporter.
I think juries know they're being played and scammed.
Exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
Yes.
Everybody knows what this is. Scuff marks from scraping on either asphalt or concrete. Yeah, this is so bad for your health. I had to jump in the pool twice today just to cool off.
Dr. Wolfe, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in any other place on Rescue Randy in this photograph?
Doesn't appear so in this photograph, no.
Can we highlight the face?
I thought road rash would happen to the skin, not to your clothing, but I think everyone gets the gist of what he's saying, including Dr. Wolfe.
What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself, on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. The second image I'd like you to take a look at. If we could have the lights for just a second.
Yeah, how could you feel upbeat and positive and feeling good about bringing your expertise to the table there in the courtroom and educate a jury when you're just treated like absolute garbage scum by the prosecutor and this judge, allowing it to be condoned? And the kind of questions he has to endure and insinuations. And I mean, it's just, a jury will not condone this, guys. I'm telling you, just because a judge does, the jury will not. I have that absolute unwavering belief that they cannot stand this sham process going on. I refuse to believe that they will condone this.
Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Trust the process.
219.
Permission to display.
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer, likely from the pavement, and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
If we can go back to the full frame, please. I'd like to show you an additional photograph.
Yeah. I mean, it's a rogue process there in the courtroom. So you tell me the jurors are not going to go rogue? Seeing all this lawlessness?
Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate?
Look what she's doing. She's not paying any attention. She's looking around and looking down, grabbing stuff, got a pen in her hand. This is not the way a judge acts. You're supposed to be engaged. Did anybody tell you that? Did you go to any kind of judicial training course that told you how to act as a judge? You obviously don't know the law, so can you at least act like a judge?
Depiction of the condition of
Hey, over
Rescue
here.
Randy in that
Over
sweatshirt
here, Judge,
after
over
that
here.
29-mile-an-hour impact.
You're supposed to act like you care about what's going on in this court of so-called law.
Yes.
Move for the admission.
You know what? I would say something to defense. If I was on the defense team and I was on this case in Texas, I'm telling you, every day I'd be motioned for recusal and it add to the list of all the abomination rulings she's given. The 39 or 49 sustains in a row that she did the other day, I'm telling you, I would keep adding to the list. The thing would be a 100-page motion by now, and just argue it every day, at least once or twice a day. And I would stand up. I'll just stand up right now. Well, actually, he's already standing. I say, Your Honor, hold on a minute. I'll tell this witness to hold up. And if the judge is not paying attention, I wouldn't proceed. I would let this judge know you're not going to pull this crap when I'm calling a witness here, okay? You're going to respect Dr. Wolfe, and you're also going to respect this process, okay? If the defense counsel has to show you how to act like a judge, then so be it. I would not let a judge get away with this if I was in a courtroom like this.
Of that photograph, Your Honor, is next in order.
Oh, back to paperwork shuffling. Yeah, nothing to do here, but, got to balance your
Permission to
checkbook.
display.
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go out back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes,
On both the fabric and the arm itself?
correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes,
Are those the chin and nose defects that you saw?
yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
Yeah, if she's whispering in her Apple Watch to convey messages, what's she ordering stuff from a grocery store? So she can just pick it up after court, doesn't have to walk into the store and they deliver it to her car.
It is inconsistent.
Well, they're surely not going to call ARCA because they want folks that are going to agree with their whacked out, non-scientific, non-physics theories that aren't based on truth.
May I approach you on it?
Yes.
Another photo that I'd like to show you.
Yeah.
Do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
I think so.
It is the rest position of the test dummy after the 29 mile per hour impact test.
Yes, I do think that they are watching this. They want to see what's going on. They don't trust this prosecutor. They don't trust the judge. Look at her. What is she writing down? What is she writing? Her autobiography on how easy it was to railroad Kieran Reed?
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph.
Okay, design rhythm. You're wondering why ARCA doesn't use the right size crash test dummy. It seems like an unforced error. No, because they compensate for it. If you do the math, I'll get to that later. If you cover the physics of it, they completely covered the issue. They don't make crash test dummies for $150,000. You think they're going to have every person's exact height, weight, arm length, etc.? No, they're not going to do that.
Okay.
That's why they do different speed tests to compensate for that.
21.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yeah, they're fed up
Yes.
with her. And
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
notice the shoes didn't come off.
If we could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy shoes?
They're still on his feet.
And this is at an impact of 29 miles per hour, correct?
Watch the form of the question. Mr.
Sure.
Jackson.
What was the, tell us one more time, what was the,
You know what, Brennan? You do leading ad nauseum. Your leading is so much more than even a cross examination, and you get away with it, and the judge never stops that. So, what a double standard hypocrite.
the speed of this impact?
This was a full on 29 mile per hour impact.
We can take that down.
Yeah.
Yes.
take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29-mile-per-hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29-mile-an-hour impact?
Yes, and I should be more specific. It's post the 29-mile-per-hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. It's 222.
Permission to display that?
Yes.
Is this the rear of the photograph that we were just talking about?
Yes,
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
correct.
Wasn't all that damage to the vehicle?
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Low-key, you're asking why the defense isn't calling it out. Well, any argument they're supposed to have outside the presence of the jury, that's what this judge wants. So I would probably not be able to contain it, and I would be blurting stuff out. So what's the judge going to do? Fire you from the case?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the Hybrid 3 arm. Do you recall that series?
Look at Karen. She looks more somber. This is obviously taking a toll on her physical, mental, emotional health. I mean, if you're given a fair trial, you can feel confident, relaxed. You know your attorney's got this. You're getting the evidence you need before jury. But when you have so much blindfolding of the jury going on, you got their ears plugged up, and you're basically just blocking so much, keeping them in the dark. It's a very, very disconcerting, very upsetting thing to sit there day after day after day. We're on 29 days of this blocking of justice going on here. So yeah, she ought to be pretty serious tone here. And despite the fact they got such a winnable case, I mean, they got so much evidence they've not been allowed to present.
Is there questions?
Yes.
You were asked how much lighter the Hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The Hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. Is that a physical arm? You can touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay.
You know what? Full melt hash values. You're saying Dr. Wolfe does not appreciate this goat rodeo's reputation being slandered by these corrupt monsters. You know, that's why I really thought that this whole Board Dyer a second go around and them not disclosing stuff that Brennan was complaining about, stupid text messages about logistics, all just a smoke screen to try to harass these guys. I really think they thought they could browbeat the arc of witnesses into not coming forward and just say, you know what, it's not worth it to have this kind of scandalous accusation by a so-called prosecutor. So we just can't get involved as a firm. Our firm is saying, hey, we got to bow out. There's no money that's worth having our names and characters dragged through the mud like this by a sham process, a so-called court of law. So I really have, the longer this absolute travesty is going on, the more respect I have for not only these ARCA experts, these most highly qualified experts, but also the ARCA leadership, for them not cowering to this bully tactic and tactics that are ongoing, been going on for multiple years by both the judge and this so-called prosecutor.
What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between 11, well, what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the kind of the final number he landed on.
Does
Sustained ask the question. Stop striking the end.
Yeah.
does 11.86
Yeah, it's like a portal to hell there, isn't it?
sound right?
Yes,
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolfe use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers.
So this is the supposed arm weight, the 11.86 of John O'Keefe versus the dummy's arm.
You're looking at just the difference between those two?
Subtract
Okay.
9.38.
Yep. 2.48.
Is there does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm that from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Look at, he was using 26% when he was doing cross, and that was the wrong percentage. It's actually 21 something. So Dr. Wolfe isn't using the proper, all the digits for the number. So
Sustained.
Is 23%
actually 21%.
smaller or no, or larger than 26%.
Sustained, let's move on from that, Mr. Jackson.
Oh yeah, don't bring up the fact that Brennan was again making up numbers. Think about that. Defense team, when he was bringing up to 26% on cross-examination, they never ran the math themselves. It's not 23% or 26% difference. The 11.84 versus minus the 9.23, I think it is. That's not 26% difference.
What is the number that you get if you were to divide 2.48 by 11.86?
.21,
There you go.
In percentages.
21%.
Thank you. Was the hybrid 3-arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
Yeah, I was thinking about that today, Janice Vetter. You're saying Massachusetts was the birthplace of our country, and this is the demise of justice system. I was thinking about that today. It's like, think about all the great founders of this nation that came from that area. I thought of Paul Revere, wrote somewhere, probably was in Canton many times and Denham many times. I think, where did he do that right? From between Lexington and Concord, where he alerted that the British are coming. I'm telling you, did the British have a worse system than this for the way they treated the subjects?
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
Yeah, of course you're not going to be granted a mistrial. Hank Brennan could do anything he wanted, and she will never declare a mistrial. That's a given. Absolute given. She's keeping her head down. You tell me she doesn't know this whole thing's a rigged scam? Or can she even see the truth?
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it.
Not yet.
You see it now.
Yes.
Do you recognize what that is?
She's not going to be convicted, so let's not talk about timeline of appeals.
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolfe?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the form again. Ask it differently.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Oh.
Were you also asked about whether it would make a material difference to the testing if you
Leo's
didn't
back.
adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained us to that point.
Would that have a material difference? With the weight of the arm, that 2.48 pounds, would that have a material difference in the testing that you undertook?
I wish
No.
I had Mike.
Why?
Yeah, so 2.48 pounds is going to matter. That's why they sped up the speed of the SUV to 29 miles an hour. Because the heavier the arm, the more damage it can cause. And so they accelerated the vehicle speed, so that makes up for that kinetic force math that he was talking about. So it's actually going to cause more damage than if you had this exact same supposed arm weight of John O'Keefe's arm, which we don't know for sure, but it's close enough that the variance isn't going to matter, and they compensated for it by going up to 29 miles an hour.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests. Okay?
I'd let him
Can
narrate
you explain
more.
to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K
There you go. Let him
mean in that
narrate.
formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn?
It's a foundational formula. You cannot ask that. You're going to object to that, Brennan. You get everything you want in on your experts. Everything. Shame
Which
on
formula?
you. High school, he said.
Probably back in high school physics.
So that's even better of an answer to
I'm
counter
going to
you,
ask
Brennan.
you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You
Your Honor,
understand?
may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay, whatever is easiest. If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result
Yeah, don't use big words like quadratic.
of squaring 24?
So again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared
Correct.
is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would
Just tell him, describe the process. I don't think Jackson needs to be going into all the details and spoon feeding him what he wants him to answer.
want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Just nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
I know what you're talking about, Susie Q. He's been paid, I think, over 300,000. I think it's over 350 now.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm
Okay,
that's being transferred.
understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour?
Yeah, think about all these numbers and small percentage variances. He's trying to make stuff up like he knows it's not a difference maker. And yet, what did we get from Welcher?
Which one?
The
Unbelievable.
29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolfe, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Objection.
Sustained.
All right, ask it a different way.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29 mile an hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29 mile an hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
All right. That could have been a lot shorter, but at least we didn't go on too long about it.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a
Yes, he's not going to call him Dr. Wolfe. Another sign of disrespect. Just like the judge.
chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
See, they know his game. He's trying to play this sneaky gotcha game. That's normal. What attorneys do is talk to their experts if there's a break in the action, there's a weekend, and he was on the stand Friday and he wasn't able to finish his testimony. So, of course, they're going to be talking to him. But because of his sneaky insinuations of some kind of wrongdoing and underhandedness by the defense, I think they decide, look, we're not going to talk to you.
No.
Other than
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about
You got nothing to go on. That's why you got to keep talking about who else they talked to.
weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you
Yeah, I don't know. You know, just mocking him right there.
answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you...
He didn't throw his hands up like that, Brennan. All theatrics, gas.
pulled that 11.8 from.
Uh-huh. And so you were suggesting that that is just a number pulled out of thin air, right?
System.
Was that a
Just pull it out of thin air. Listen to that. I'm going to back that up. This is
0.8 from.
And so you were suggesting
a real court, you'd get chewed out by talking to a doctor this way.
Saying that that is just a number pulled out of thin air, right?
Sustained.
Was that
She never admonishes him, no matter what he does. She never says, knock it off. That's enough, counselor.
a surprising
He has no problems doing that for the defense.
estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an
Yeah, so will the defense ask these kind of questions to Welcher? Like he's asking, when's the last time you talked to him? How long did you talk to him? What'd you talk to him about? Spend a half an hour talking about that kind of stuff.
arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
Like, you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm.
How much was he talking about the arm last week, and now he's vomiting that stuff again this week? Unreal.
So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is,
So it's sustained. Ask the question again.
I'll ask you again.
Look at him leaning against there like that. I've never seen a prosecutor do that before. Leaning back against something to prop him up in the courtroom.
Doctor, tell us where you got the 9.38 pound value from when considering a 6'1", 216-pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 260?
Can't get off it.
Where?
That's the only thing he's got. He's explained already how this doesn't matter. A few pounds does not matter.
A source to say that arm is validated for use for that size man. Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Is that your answer? I mean, just how cringy, and it's a bully comment. If you just look at that comment alone, if somebody says, is that your answer? But coming from him, it's a bully move.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile, isn't that fair to say?
Correct.
And there is, in fact, a 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50th percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no study,
Listen to
no
that.
paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
Don't need.
I don't agree with that because, again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
You have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that, or answer that question, please?
Sorry, can you repeat the
You
question?
have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
Well, he's going to try to, but Brennan's trying to keep them all out.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Sustained.
Are you confused how the number 11.8 would come up?
Now he's talking like he did to Dr. Russell. So what a disgrace.
I'm going to allow that.
I'm not confused. I don't know your source for it.
When you do studies, would you agree that the head has a
What did Welcher do? He didn't do any kind of math at all. No physics, no formulas.
similar weight to the arm, and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment
No, he's not.
of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I
Good.
worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I
Okay.
don't have the percentage off
So
the
if
top
you
of my head.
take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah,
Just over 9 pounds,
okay. Close to 9.38?
9.37.
Okay, now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Look, she's still up
Yes.
there shuffling, moving around. Unbelievable. Yeah.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes,
You testified before under oath in this case, didn't you?
correct.
And when you testified under oath, and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath,
Yes.
right? You can't delete something that's under oath, right?
Sustained.
And so when you feign confusion
Just nasty, nasty persona here by Brennan.
on Friday about this 11 pounds,
Sustained.
What did he say? Doing feeding confusion Friday? I mean, you would get your head ripped off by a judge if you tried doing this, especially in federal
in your
court.
training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath,
Yes.
right?
Under
You
oath.
can't delete something that's under oath, right?
What a absolute jerk.
Sustained.
And so when you
Sustained,
feign
but never scolding him. Never scolding him. Unbelievable. I just
confusion on Friday about this 11 pounds,
Sustained.
under oath, right? In your training, you said.
I want
it
to
was
hear
around-
that confusion.
And so when you feign confusion on Friday about
When you feign confusion, when you're faking confusion on Friday, I mean, I just can't believe this is like one of the worst things I've ever seen. How does it get even worse than that? Disrespecting somebody like that? I tell you what, this guy'd probably get beat up outside the courtroom in a lot of courts. Okay, there wasn't so many cops around there.
this 11 pounds.
Sustained.
So when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds.
Yeah, just keep doing it. She'll be sustaining stuff, even if it's that verbally abusive and a bully tactic. But he's going to keep doing it. He doesn't have to stop doing anything he wants. He has free reign. You might as well not even have a judge there.
Before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so.
Well, we just did the math, didn't we?
Yes,
Okay. And you used the calculator to help you, didn't you?
I did,
The
yes.
calculator works.
Yes.
Okay.
Okay, Dan DeStefano, sorry, I'm saying your name, maybe wrong. In a normal trial, in normal circumstance, do you think a judge could stop this harassment of a witness? Well, first of all these antics he's doing, these demeaning, abusive antics, stunts he's pulling here, a judge would chew him out if he tried doing this. Because think about it, this is a court of law. You're supposed to have dignity. You're supposed to have all this decorum and professionalism. It's supposed to be something like it's like the pillars of honor and righteousness and good, wholesome things that the government is doing to hold those evil people accountable. And here it's just like a joke. It's like a clown show. It's like some kind of spoof. It's like nothing's taken seriously here. There's no professional judicial type decorum. She doesn't have the demeanor and temperament of a judge at all. So it's like you're just playing court with some kids. You're playing court with kids, and you got some fifth grader like Brennan. And anyway, I just got to keep thinking this doesn't pay in the end. This is not going to work in the end. So let them have their little winning battles with this fake judge, because in the end they're going to get not guilty. So
You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
and then you divided it by 11.86. Divide 2.48 by, from the 9.38.
Okay.
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I
Didn't ask you. I'm asking if you would agree with that.
can you repeat the question, please?
So ask the question.
Does the arm weight weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including
Yeah, if he doesn't get the answer he wants, he keeps asking the same question. A lot of times the same way, just to harass and
the
berate
hand,
the
forearm,
witness.
and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
Sorry.
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier. Is you would increase the mass, you multiply it by the acceleration. That's going to increase your force. Force is equal to mass times acceleration.
That'd be a good
Right.
one.
So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm. Yes.
Right. So weight matters, doesn't it, sir?
Yes.
Still talking about this. Wow.
Force is mass
Unbelievable.
times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct. Yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference and weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you
Nasty.
explain to the
Talk about an ugly, nasty attorney. Wow. I've never seen anybody uglier in a court of law as an attorney, and you're supposed to represent the government. I've never seen a defense lawyer even act that.
jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations?
Still talking about.
you
That's
break
all
it
he's
down
got,
for-
folks. That's all he's got.
Well, I think it was
2
it was certainly
pounds.
stated. I mean, I know that we went over Newton's second law: force is equal to mass times.
Do you really think he's that clueless, or do you think he's just gaslighting and trying to confuse the jury? He thinks the jury's so confused by this guy's testimony that he's just going to keep going over and over again. He's just recycling the same garbage over and over. And then the jury's going to wait a minute. What's he talking about? He keeps talking about this 2 point. It must be important because he keeps talking about it. No, it's not important at all. It's just nothing but outright sheer gaslighting.
Acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate
Oh
the
my
force for the
gosh.
speed of test so it looked like
Look at that sleazy type of underhanded. My
The
God.
collision had to happen at a faster speed to cause a certain amount of damage. Were you doing that intentionally?
Listen to what a loaded slime ball question that is. Welcher had no math. Unbelievable.
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have
No, but the speed made up for it when he did 29, and you know that. So he's just trying to play stupid in front of the jury.
created the opposite illusion, right? You use a weight that was
Jury's not that
lighter
stupid, Hank.
than Mr.
They're sick
O'Keefe's
of you.
estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm,
I've never seen an attorney go over and over and over and over again. I mean, what's he been on this 90 minutes now between last week and this week now? And he's got nothing to show for it. He's got nothing to show for it other than the fact that he's nothing but despicable.
you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting
Say it
aside the
boldly.
fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummies arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you
Yeah, Julie Nelson, poor Dr. Wolfe isn't accustomed to this crappy treatment. Yeah, I guarantee you he's never had this much of a garbage fake court before to deal with.
I'm not aware of those studies, no.
as a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your work, in your profession, that suggests or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Renfro. Can I finish, please?
No.
Okay.
No.
So,
Can I? You cut him off, and then he asks, "Can I finish, please?" And you say no. This is okay, guys.
no comment, Mr. Brennan. Answer the question, please.
Yeah, never a warning. Like that's the last straw. You hadn't better do that again. It's just you're a joke. You're a joke. Your decisions are an absolute joke.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
So what he's trying to do is ask him questions that Rentschler's an expert on, and then he's going to block Rentschler from trying to talk about that. So this is how this whole thing is.
There were no holes
Worse
or
than a kangaroo
cuts in
court.
the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and
If you guys have ever seen a more disrespectful lawyer on anything YouTube, send it to me because you won't find anything more outrageous, disgusting than this guy.
holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the tail light.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is of vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm,
This is void.
using a hybrid arm
You're
doesn't
sick.
seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human that pushes different than the crash test dummy,
just gotta laugh.
would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
So what happens when you have a corrupt process, a corrupt system? You get away with anything.
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in tests A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolfe?
Oh man.
And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones that you use for test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you use Randy and
Maxime is
brought him
right.
into the scene, you use the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
wear and tear.
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever?
Gosh.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like?
What else? What if it wasn't manufactured in the same lot? What if the fabric came from a different factory? before it came to the manufacturing plant. What if it had different humidity in the plant? Would that affect its ability to withstand those rips? I just think it's so
No.
insane.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this
Who cares?
before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis
Ever.
and offered an opinion in front of a jury on this.
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables
Unreal.
that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
You're the one testifying, giving opinions to this jury, yes?
He keeps talking about you're under oath, you're under oath, you're under. That is so insulting for a guy like this.
Yes.
You're the one asking them to rely on your experience and training, true?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
When wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of
You
opinions to this jury. You
offered
personally,
the
under
opinion.
your name, you came in and presented yourself as an expert in this subject. You didn't.
Not for bodily injury. He keeps lying about this. I mean, I hope the jury's not that stupid. They can't see all this gaslighting. Unbelievable.
You?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
It's not a court
You
of
wrote a
law.
report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, "It is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis"?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
The objection sustained.
Did you agree with that?
That's all he's got.
Sustained.
Gaslighting,
Did you write
deception.
or endorse, these
projection.
injuries would not result from impact with a non-damaged tail lamp cover, and the amount of force required to fracture the tail light cover would
So we're gonna see you inside, Bob.
Yeah, he's out of control. He's unhinged. Even the judge is thinking you're screwing up this case. All right, so let's see here. They're on sidebar for. Got to jump all the way to 11. 211. Yeah. He's getting more desperate. He's losing it.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass that, or plastic that shatters from a taillight might not impale clothes of the skin, would you agree, if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off?
It doesn't drag an
Would you
arm.
agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Drag an arm?
Sorry, can you repeat the question?
Yes.
It blasts the arm out
Would
of the
you
way.
agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side,
And
yes.
so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if
when
I
say
understand.
drag, push. How about we use the word push?
Push.
Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moves the vehicle, sometimes it moves even faster.
Never seen anything like it. I can't believe anybody would let this guy with this personality handle a case.
Just in space between the broken taillight and the arm.
It's an
That's what you're
embarrassment.
suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes?
There's no shame here. There's no shame for the way he's treating people. There's no shame by the judge for the way he's treating people. There's no shame by the judge not stopping this mockery of any semblance of justice in a judicial forum here. This is supposed to be a court of law. It's just like a mud wrestling mud pit that you and Hank Brennan are trying to pull people into.
And drags against the arm.
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken tail light? That's the simple question I'm asking you. Could it be pushed by the broken tail light?
Just moving
Pushed.
adjacent with the taillight, just moving along. Yes.
I mean, this guy's like lost his mind. He's not even making any sense anymore. He's just thinking, like some of you said here, he's running out the clock. He's just thinking, I gotta keep asking questions, circular, just bozo type questions, just to be asking something and to make this guy be tired of me. Because if this guy's tired of answering questions, he's going to look like he's doesn't know what he's talking about, or some weird theory like that Brennan's thinking. But Hank's making the fool.
Would you agree with this?
Out of himself.
If you have an arm struck at 25 miles per hour, to get significant more damage that tail light shatters, hits and moves forward into arms, parts of tail light pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken tail light can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
Pushing, it doesn't push. It slams into it, knocks it out of the way. That's not push.
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is
For like what we saw in his chart, just like minute hundredths of a second, instantaneous virtually.
being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity.
The operative word here is push. And so, do you like to agree with me? You could disagree with me. Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
I mean, think about all this cross-examination, folks. Cross-examination, like maybe you've seen TV shows, Perry Mason, or Matlock, or shows like that. They really get some really good points on cross-examination, and they win the case on cross-examination. Here, he's just going round and round the mountain, round and round the mountain. Just nothing he says has gained any traction with the jury. He's not making and scoring any points at all. He's not laid a glove on this Dr. Wolfe at all. Dr. Wolfe is handle it better than anybody could possibly handle this kind of treatment gone on since last week. And then he has to spend this time driving. Apparently he drove up from the Pittsburgh area to get back to Boston, and to be then knowing he's going to be treated like a dog like this. So I tell you what, I think the jurors are going to, he can't speak out and do anything about Brennan, but guess what? The jury members can.
When you were showing those photographs today regarding Test F, now you used Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16
Oh my gosh, that's 1 inch difference. That's too much. Why didn't you get a 6'1", Randy?
pounds less than Mr. O'Keefe.
And 16 pounds is, that's a major amount.
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, What happens when you have 200 pounds of mass strike the vehicle?
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H.
But Hank thinks you shouldn't. Why didn't you dress up with blue paint on your arm and have someone bump into you at 1.9 miles an hour? That would be a real test. That'd be a real scientific test, Dr. Wolfe. Don't you get it? Yeah, you guys need to go to jury duty. Don't you all realize that's the last stopgap measure to stop these rogue tyrants from crushing people's freedoms? If somebody's guilty, you need to convict them because the evidence is presented that's credible and proven beyond a reasonable doubt, then you should do your job and convict the person. But if they have to resort to lies, trickery, deception, and all this games and blocking truth after truth after truth from coming in, we need people that have character and integrity on the juries. Because if we don't, and we just have people that are the ones that can't figure out how to get out of it, as though they're the ones that are left, and who's going to hold these tyrants in check?
395 MPED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
I did a video a couple weeks ago that talks about, it's a scorecard for the judge and talks about what you guys can do if you're interested in doing something to complain.
Is one way, yes.
Right. So that way you don't have to put the dummy on a forklift and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to?
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
Vince, the Dinah, you're saying, do I believe charisma is a top 5 quality of a great defense attorney must have? No, that's not a must have. If you have charisma, that's a benefit, but it's not a crucial thing to have. I'd say what's more crucial is that you're competent in the law. You are zealous and unturning every stone to find facts for your case. You have to have credibility in front of a jury. You have to have likability, because you can have a charismatic personality, but be a total slime ball. Okay, so you need to have credible, likable personality. So charisma, to me, sort of almost has like you're sort of a slick talker or something like that. But Well, Dr. Wolf's a good example of a positive charisma. I think he's got charisma here. The jury likes him, they trust him, and they believe that he knows his trade, his skill set here. He's from a top-notch firm. They don't clown around and do jokes for tests, and he's doing it to industry standards. Unlike what we saw from Dr. Welch, you're going to tell me that was an industry standard, him doing his blue paint kind of thing. So anyway, that's why I think any of the defense attorneys could be good on the closing here. I think they're going to go with Brennan, but I think Alessi'd also be good because he has so much conviction the way he speaks. But if they only have an hour to do a closing, hopefully the judge will allow him to do it at least 90 minutes. And you need to talk really fast. I think Jackson can talk the fastest. So it might be him, but I could also see Alessi doing it, and I think he would be very effective as well.
And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah.
That's a common sense, no-brainer question. Just Google Karen Reed Defense Fund. You'll see the link there. It was posted by my brother a couple weeks ago, but just Google it and you can find it.
And the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
And finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears?
This is like not even relevant to what he's testified about.
And lacerations?
No, sir.
He wasn't there to talk about tears and lacerations. That's what Rentschler's there for.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Sustained.
All that doesn't matter because the crash did not happen. So who cares what was there on the ground?
Did you
He's looking at the physics of it, not some little drinking glass that was there, supposedly in the hands of John O'Keefe.
talked about cuts and injuries? Did you?
Sustained. It sounds like it's beyond the scope.
Very
Yeah, it's beyond the scope. It's for Dr. Rentschler.
well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
When they're talking about all these G's, I wish they'd break it down like they had talked about earlier, PSI. So how many G's, 180, 780, what does that exactly mean? So I think they need to explain that to the jury better.
Page 11 of your report.
I think I lost an exhibit.
France, you're asking, how do I see social media changing the landscape of a judicial system? I think it can help because a lot of people in this case are helping Karen Reed get money to help support hiring experts like this. Think about if Karen had no money and nobody knew about this case and cameras weren't allowed in the courtroom, she wouldn't be able to present this kind of defense.
Okay.
So I
Is
think
that what you
social media
described it as?
and also having live coverage of trials is even bigger because that what feeds into the social media coverage.
For test D,
Yes.
the acceleration of, we talk about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Beyond the scope, Mr. Brennan.
Yeah, they never talked about it
A few more questions.
on
Dr.
redirect. He's trying to go outside of it.
You showed us holes in Randy's sweatshirt from Test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Look what he's doing. See what's behind Dr. Wolfe? Look at that. He's going to pull the plexiglass. All right, so this is a 225/55. This is the hoodie.
Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. You see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look.
This is the major deal here. So he's pulling this stunt, misleading the jury, the court, and this witness on what these supposed holes are about. I wondered when this was put in plexiglass, what stunt he's going to pull with this plexiglass. So this plexiglass, I believe, was put there to try to flatten this out so they can actually see the holes more on the back. And this thing is going to blow up in his face here, but he doesn't know it because he thinks the defense is going to catch it. So watch how he misleads this court.
I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
when you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with.
I think it's trickery. He's trying to pull a stunt with this plexiglass framing of the hoodie.
Road rash.
Didn't ask that question. Did you consider?
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider
He's asking all these follow-ups to the holes that he's saying are in the back of the throat area on that hoodie.
the multiple holes on the back of his sweatshirt
Look at that.
when you came and formulated your opinions?
These holes were done by the lab. They cut open the holes to do samples.
No.
Unreal.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken.
There he goes. Cold, hard ground. How about the grass? On the thick grass? So the defense, yeah, they didn't catch this. This is Brennan. This is Brennan here doing the direct. So Brennan should have been the one objecting here. So I think Alessi is the one that caught it. So we'll see what's going on here.
Taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, where was Lally? You think Lally didn't know that, and this Laura, their sidekick, didn't know that he's pulling a stunt like this? You guys think he doesn't know what he's doing? You tell me he didn't look over every little detail about what they did to that hoodie at the crime lab? Yeah, Jackson should have been objecting to misstating the evidence.
If I may, Your Honor, very briefly. You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
The objection sustained.
You were asked, give me one name.
Yeah, keep going. Judge says, if there's an objection, she says sustained. Just keep going. That's what Hank does.
To support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher?
Yeah.
How about that name?
So the objection sustained.
Oh yeah.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
Yep.
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
There you go. He's making a big deal out of like this guy's an incompetent accident reconstructionist, and there you go. Total projection.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the
Using
force
Jackson and Brennan, so it's very mind-numbing to deal with these people.
equation, on the force calculation, correct?
Correct.
And you
You guys know, I think, who I'm talking about, so my apologies.
agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3-arm,
You think Karen caught it?
were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm area of the taillight? 14%?
Yes.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
I'll allow it.
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were,
Objection.
So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know, he was asked questions, Your
That's
Honor.
the end of that, Mr. Jackson.
Yeah, see how she gets firm in her tone? She's never done that once with all the stunts that this Brennan has pulled.
Do you have the, Mr. Wolfe, do you have the picture of the tin? The TIN, tin, the little round tin? Do you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Sustained. And
He doesn't want the truth coming
jury's
out.
disregard
So
that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
well, jury got it out anyway.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
Okay. In your testing, how long did it take the hybrid 3-arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again, about
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
The objection sustained and it's struck.
Yeah, for what, leading? And you
In every
often
one of your
lead.
tests, every single
Every
one of
day.
your tests, did any taillight fragment tear a hole
They're
in
set for this.
in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, What happened to the back of the license, the test license?
Destroyed.
Okay.
I have follow-up questions.
Okay, go ahead.
Just a couple minutes of cross here. Let's see. Recross, I should say.
On redirect, you again talked about the impact between an arm and the broken taillight.
Correct, yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm, if it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Okay. It's okay, Leo.
Objection, the source.
No,
Dr. Rentschler, do you agree with that?
Objection.
so I'm going to allow it, strike the source.
Do you agree with that?
I'm sorry, can you repeat?
Leo's up here trying to reassure me. He's tired of listening to Brennan as well.
Again, if you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection,
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Do you agree with that?
I'm going to allow it.
I need to.
Yeah, that's what prosecution witnesses have been famous for. Except they're really trying to play stupid with defense questioning. He's not trying to play stupid. I think he just knows these are stupid questions, make him ask it over and over because he's going to keep asking over and over anyway. All right, let's see. Let me look here. This is going till 43.
I'm going to read this one more time, okay?
Okay.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm. So whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please.
He can't concede the loss. He keeps going over and over again.
And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken.
The jury's got to be like wanting to just poke their eyes out at this point,
taillight.
saying, "Somebody just shoot me! I can't take this guy anymore. Get him out
It's
of
going to
here."
move with the arm.
Thank you.
All right, so jurors, we're going to take our morning recess. We'll see you in about 20 minutes.
Please rise for the jury. Right this way.
Okay, they're going to come back here.
Would you agree with?
And so let's see. So apparently Karen's the one that caught that. That Brennan pulled that stunt.
Issues has arisen.
All right, so I'm told counsel wanted to see me.
Issues has arisen related to cross-examination, re-cross-examination of the last witness, and Mr. Alessi would like to address the in detail about that.
All right, so the last witness was your witness. Is there a reason?
This is a separate issue. I'm asking Mr. Alessi to address the court on this.
Okay. What do you want to tell me, Mr. Leslie?
Okay, Microdot's covered it.
Bear with me a moment, Your Honor. I need to put on evidence gloves.
Leslie lit him up.
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have two documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked,
No, jury's not there for this.
what I would like to have marked, the first document, and I want to get the specific title. These two documents are from the criminalist file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. For ID.
And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ for the identification.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why, for identification appears to support
She
that.
can't tell. Oh, really?
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter. Your Honor, what we just saw is Attorney Brennan question Dr. Wolfe with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor. The
Okay.
first time I realized that line
Okay.
of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing, without notice, shows it to Dr. Wolfe, and shows the back of the hoodie, which has certain...
Yeah. You notice how she just objects and basically cuts him off, trying to steal his thunder, kill his momentum. How nice of that. You know, she never once has interrupted in 29 days. She never once has interrupted Hank Brennan. It's like Hank is her boss.
holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now.
You know what? All this doesn't matter. Let him argue first. Let him keep his train of thought.
Absolutely, Your
Mr.
Honor.
Leslie.
So here is
Unbelievable.
the back
Okay,
of the hoodie.
okay. All right, thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get to back to this in a moment. But I would like to do it, and certainly entertain any of your Honor's questions, but in a logical order.
Sure, so I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right, thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolfe, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolfe, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and Impact at 24.
This is basically argument for the record, because this judge will never grant a mistrial.
29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolfe is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that? Does
Yes,
that do
Your
the
Honor.
back?
What
Okay.
we have is two
Doesn't
documents
matter. You
to
don't
show
care.
that.
Right, so
Won't
the
do anything about
second
it.
one.
You won't even scold
when
Brennan
was
about it.
That
Do
provided.
him out.
These, when you say provided, you
proper
mean with
training.
regard to when did the defense get these in
Yes. Oh,
a
great.
discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence. Not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents.
You're telling me you didn't introduce that as a mistake? This was planned all along, folks. That's what it looks like. Follow the trail.
Are not in evidence, because if they were.
And then he can figure that out along with the plexiglass. This has been a calculated move, it looks like, for a long time.
In evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolfe. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminal.
I've never seen an appellate attorney sitting there in the courtroom watching a trial. It's unheard of. Unreal. But you know what? They know they're going to have a lot to answer for if she ever gets convicted, if Karen Reed ever gets convicted. And they're not going to be able to.
Criminalists made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-218-4. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what, can you bring it up to me, please?
I certainly can, Your Honor.
You know, cutting them off again.
I can
As soon as
conduct
you
my
get more
argument
ways,
from
you want
right
to cut
here,
it
then,
down.
Your
I
Honor.
just want to see, point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie, that's the back.
All you have to do is get appointed by the governor,
And then you can see the various,
have political connections. You can be appointed to any judgeship if there's a vacancy.
let me just get a check on this, Your Honor. I'm not,
Mr. Brennan, you should come up and look at this as well.
Thank you.
and I'm,
So, Mr. Leslie's taking it.
yes.
All right, so this is why.
Oh, Brennan doesn't know what they look like? Never studied those, Hank Brennan?
Can I get the check? Pardon me? Right, but if I can, Your Honor, I want to clarify this. Yes, you will, Mr. Martin. Let me just make sure I get.
Mr. Jackson, it says exterior front, what Mr. Alessi was pointing me to.
Well, just a second. It may have printed the wrong page. I can do it, but Mr. Wolfe, can you print the back? And Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
I understood. We will. He's printing it right now. We printed, we wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
Yeah, Brennan's there texting, it looks like. No, judge's notes aren't part of the record unless they make a ruling. Rulings are part of the record, but not their notes.
If I may, Your Honor, I'm advised it will take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor. So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is
Brennan.
the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can we print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
Thank you, Madam Court Reporter. Sure. And here's another document, chain of custody document.
All right, this is,
And both up to your honors. Well, Mr. Brennan is reviewing that. I may head to Madam Court Reporter, the chain of custody document for these, and ask that he mark as the next exhibit in order.
Okay?
And then with your honor's permission, I would have Madam Court Reporter hand them both up to your honor so
Sure.
your honor can see what I'm writing.
Thank you.
Exhibit B for ID.
Thank you.
Here it is. Thank you, Madam Court Reporter.
Do you need this, Mr. Lessie?
I do not need either of them, Your Honor, and I have the extra copies as well.
whole thing gets slowed down.
Okay, so Your Honor, I now have enough copies
So
for
if you
Your
cut him
Honor.
off, unless he wasn't able to finish his points, look at the documents.
So if I could
Let him
have
finish
one
his
set,
argument,
that
and then
would
look
be
at the
great.
documents.
Yeah, Your Honor, thank you.
I still do not have ZZZ.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolfe, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th
Exactly.
of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic. before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
right,
that.
that's what, and I'm going to
let's
come
move
back
on.
to
Everyone
this.
says that's a
Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolfe, the ARCA expert, to try to make it seem like Dr. Wolfe didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolfe on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear.
Trampled on.
The more
That's what I
desperate the
used a lot. Trampling, or the Constitution is being trampled. So I like that word, what they're doing here.
Prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Brennan.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Wow, he owned a mistake only.
And so I think what should happen is there should be a curative instruction.
Oh, just cure it.
There
Now
should
they
be a
got caught.
stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolfe about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt.
So at least he's recreating and saying that during the cross-examination, he's given a little storyline of what happened here.
Parties agree the holes were made by a crime lab technician. This was
It shouldn't be the parties agree. The judge should declare it.
done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right.
He's concerned. I tell you what,
So
he's busted.
I'm not going to allow the mistrial motion, Mr.
Of course
Lessie.
not.
What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolfe, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they...
She's not even mad about this. She's not even concerned. It's just like, okay, I'll cover you. I got your back, Brennan. No worries. Yeah, she's really red-faced. Look at that.
perhaps could have come from events or implying or something like this.
Oh, just something. You don't have to get it accurate.
I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on...
Yeah,
I just
defense
put the
attorneys had
dates
been
as
like
well. Chrissy, can I see those
put in
dates?
for bar complaints, try to get disbarred.
It's unclear for me. Do you have a better idea, Mr. Lessie, what day
Just not a big deal. Yeah.
these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates?
Your Honor, on or about May 18th, when the defense filed a motion to test, so that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's
Right, let me s-
2020.
Saved regard. So I'll hear you, go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up, because that's what
Okay.
happened.
Yes.
in-
Yes.
These holes in the
Yes.
back.
Yes.
Okay, thank you. So that's number one as part of the stipulation, and then.
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's, I do the result. All right, we can bring the jury. All right, so it's what I said, Mr. Lessie. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present?
What about bringing up the fact that during the cross-examination by Hank Brennan, the questions posed about the back of the hoodie, going into the recreating when this happened. There's no discussion right now in her proposal about how this unfolded when Dr. Wolfe was on the stand.
In the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolfe about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Yeah. So in other words, Brennan just made
Just as a housekeeping
simple
matter,
mistake, right?
The sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, it might need to have it marked. But we don't need to do that right this second.
Okay.
May I approach Mr. McDermott with exhibit
Yes.
88?
Thank you.
All right, thank you. I'm sorry.
All right, hold on.
Remarked.
I can just leave sampling of the sign 2025 to draw an inference. All right, so it's what I said, Mr. Lessie. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist Ms. Harnett during the course of her inspection of January. Not going to listen to her result. Sure. I instruct you that
I'm backing up here.
rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolfe about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in.
Look at that. So right there, unless he was discussing with the other attorneys any final edits to this, they're having to confer among themselves as she's just writing this out. And what does she do? She gets in this little hissy fit here, and then right away is going to call in the jury.
It's what I said, Mr. Alessi.
Just this is not anything like I've ever seen.
Okay.
All I can say, this is
All right, so
A
it's what I
farce.
said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the
nasty.
criminal. Right,
Yes, Your Honor.
okay.
It's disgraceful.
Sure. Okay, thank you. Why don't you go ahead and put it back in the bag?
Why didn't she say I granted the defense objection that this was misleading to the court. This is not something that was done at the scene as alleged by the prosecution. In fact, it was done at the lab many weeks later. The prosecution was completely wrong and inaccurate on this, and go on and on like that. But the prosecution is like, oh, it's just not a big deal. She's just making it sound like it's a simple fix, just an honest, simple mistake, right?
So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt.
Not draw an inference. Yeah, an inference. It is weak. I agree with you on that.
Back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll, Mr. Yannetti, your next witness, please.
Ugly as it can get. It's not a real court of law. Yep. Snaps at them, nothing
Speak
for.
to the court and jury in the case now, we're here to the truth, the whole truth, and nothing but the truth, so help me God. I do. Thank you.
All right,
Try that-
good
tries to-
afternoon.
Hoodwink the
Go ahead,
jury.
Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last
Private
name?
investigator.
Sure, my name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
Yeah, actually, she did say the wrong year, didn't she? Instead of 2022.
I have
Unbelievable.
my own firm.
What is the name?
Forum Investigations.
And that's FORUM?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston
Where-
proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School,
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University,
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location, sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations,
He's asked to
all
go to-
sorts of things, anything involving a Social Security number, basically.
And why did you leave?
34 Fairview
in
gets the
2008?
measurements. The
I
judge
went
did
to
not
law
allow
school.
him
Where?
to present any photos through direct examination. Unity was not allowed to do so. And then there's a sudden interruption here. And then they go to lunch.
That portion?
Well, the jury does. Then they do voir dire of Dr. Elizabeth Laposada. All right. So he had right there. He
Can you
showed.
continue, please?
And then past that to the right, there are the windows, and then if you can see the little red line, that is
He's talking about the 3 doors there. So he did measurements from the mailbox to those 2 different doors on the right. And
a side
aimed
door
them
that
up.
goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
And the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wilk, put the lights on. May I approach the witness, Your Honor?
Yes.
Photograph that I took of the
To the layout.
All right. So here they're going to go. after a sidebar.
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point, okay?
She wanted photographs. They go to lunch. The jury does, but here, let's see here.
All right.
Or Dyer.
So we'll
Absolute
fix that
zero.
during the luncheon break, Ms. Giannetti, to what I said. All right. So can we get Dr. Lapasada in here? We'll do a very brief voir dire of her.
She was a chief medical examiner for the state of Rhode Island for 12 years, has conducted over 3,000 autopsies and supervised over 7,000 more. Been qualified as an expert hundreds of times, but you can't get her in this courtroom to talk about all the stuff she's qualified to talk about, including dog bite pattern recognition. It's just
No problem.
insane.
For purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those two areas. And if there is support or methodology in Dr. Lapasada's resume to point to exactly where that is, okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Lapasada, that's spelled Laposata.
Dr. Lapasada, what do you do for a living?
I'm a medical doctor.
So the jury's not there right now, but let's just jump ahead. Despite all those massive qualifications, she's been practicing for 40 years with those kind of numbers on autopsies. She's dog bite recognition often
Seminars and case
included.
reports.
Do you list any of those classes or seminars on your resume?
She's done about 50 of them, and she can't, the judge doesn't allow her to talk about that. I mean, it's just ridiculous. I don't even want to see this right here. It's just absolutely outrageous. And yet you got guys like Burgess that can testify. He didn't have to get voir dired at all about his bogus representation, pursuing a bachelor's for 17 years. Unbelievable. Okay, so here.
Matter. And portion of the next sentence is also out. This results in bruising or bleeding under.
So they're trying to keep out all the different stuff that's really relevant, truthful stuff. Brennan's trying to keep out.
Thank you, Your Honor.
And now the PI guy comes.
Sir, before the lunch break, you had identified, what do you see on
To the
this
left.
photo, particularly with regard to the third entrance, the one in red? Could you describe that?
That one goes to the garage.
Yes, so it's
Or
if you're
right one.
if you're facing the house,
Go into the garage directly. Westerly direction. Did you see
to the
driveway next to the?
and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
I think you got it right, sir.
Okay.
So that's mailbox to the front door. Then he did the mailbox to the second front door, walking along the driveway. That's 70 feet 1 inch.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, a right.
Almost the whole hall to went to
that's
the on
gonna
Crest
jump ahead
Street
here.
magnify. Yeah, that's it. As to what this
Correct.
on.
Had a wheel to measure?
Correct.
You way to, and the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet 3 inches, I believe.
Is it one way?
Correct.
And back is another 78 feet.
Correct.
When you measured these, was it from the asphalt? From the,
Not with
Jump ahead here to the doctor.
May I inquire?
Yes, and Dr. Lapasada, please speak right into that microphone,
I
okay?
will.
Thank you.
Doctor, can you please state your full name and spell your last name for the
qualified.
jurors?
Yes, Dr. Elizabeth Laposata,
Brilliant,
spelled
doctor.
Laposata.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Better?
That's better.
Okay.
That's better. Doctor, can you tell the jurors what you do for a living?
Yes, I'm a medical doctor and I subspecialize in forensic pathology.
Can you summarize your professional background?
Certainly, I graduated in 1975 from Bucknell University with a Bachelor of Science in Biology. I went to University of Maryland School of Medicine, where I graduated in 1979 with a Doctor of Medicine. I did my internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice, and I'm also an associate professor at Brown University School of Medicine.
How long have you taught at Brown University School of Medicine?
Since
Ivy League.
1993.
And how long have you been a clinical associate professor of pathology either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second-year medical students. I teach a lecture in diseases of the heart, cardiomyopathy, and myocarditis. And I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic pathology in some way or another?
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were inactive, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
At some point after you graduated from the University of Maryland School of Medicine, did you complete any residencies?
Yes, I did my residency at, excuse me, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do
Johns Hopkins in Baltimore is basically the #1 ranked hospital in the world.
any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little, what is the difference between forensic pathology and anatomic pathology?
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at postmortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death, and that can be sudden unexpected death or death due to violence.
And in forensic pathology, is that often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation, the whole gamut of ways people can die unnaturally.
And what type, to contrast that, what types of cases did you work on during your anatomic pathology residency?
There, you're mainly dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes, yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
Were you a research associate at the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Law?
Yes.
I'm sorry, School of Medicine?
Yes.
Old habits. What about postdoctoral research fellow? Were you ever a postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, excuse me, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital at the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division of the Department of
She's
Medicine
qualified.
at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, made sure I had adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative staff. So running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as the co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being chief medical examiner.
Tell us a little bit about that. What was that appointment?
Well, there's a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death.
How long did you serve as the chief medical examiner in the state of Rhode Island?
For 12 years.
Starting when and ending when?
Starting in 1993 and ending in 2005.
As the chief medical examiner for Rhode Island, did you ever have the responsibility to work on any mass disaster cases?
Unfortunately, yes.
Okay, tell us a little bit about that. If you could start with the Egypt Air issue.
Yes. Excuse me, I'm so sorry. In 1999, the Egypt Air 990 was took off from New York airport, and it crashed off the coast of Massachusetts, and 2,065 passengers died. And because of the force of the airplane going into the water, all the bodies were fragmented. So they were brought, all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash, and that involved working with FBI, TSA to identify those individuals and understand exactly why they died.
What was your role and the role of your staff that you supervised in dealing with those other government agencies, the FBI, the NTSA, other entities, in terms of the fatalities that you did review as a medical examiner, the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families.
Doctor, did you also deal with the tragic station nightclub fire?
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
Were you successful, or your staff successful in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task
I
task
was.
force. Before you became the chief medical examiner in Rhode Island, did you previously work as a medical examiner under somebody else?
Yes.
Yeah, the bar to being an expert is not that high, and you don't have to have previous testimony at all. Otherwise, how could anybody ever become an expert witness if they were never allowed to testify for the first time? So, but what this court's doing is like, no, you have to have like a thicker resume that's padded with more kind of dog bite attack analyses that you have in your causation. So it's just unbelievable the difference. All the defense experts have to go through this. What should I call it? A humiliating voir dire, and none of these jokes they got for the prosecutor office, other than I take an exception to the medical examiner, had to go through this. So it's really ridiculous.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia?
Yeah, so after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia. Yeah. After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Dr. La Posada, can we put dates on that? Assistant medical examiner in St. Louis from when to when? Do you remember?
Oh my, let's see. May I look at my CV?
Sure, with the court's permission.
Yes. Okay. Yes, from 1983 to 85, I was an assistant medical examiner for the city of St. Louis. Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
She's in places that really have a lot of murders, right? So she's seen a lot of violent crime and also dog attacks.
Thank you for that. Dr. La Posada, have you held any faculty positions as a in the field of forensic pathology that qualify you as an expert in this case?
Yes, continue
Jump ahead.
especially non-natural and traumatic deaths.
With regard to your teaching responsibilities specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a lecturer in the role of medical examiner? Did you do a 19 lecture?
That particular in forensic.
That a division of the graduate
Forensic science.
and
What medical sciences? Great.
She's done it all.
did you?
Yeah, I ran
Can you describe your?
well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started.
So she taught folks how to do autopsies, supervised over 7,000 autopsies, teaching students, and she doesn't have credentials to talk about dog bites. Unbelievable. I'm just gonna.
You mentioned several topics about which you testified and qualified as an expert. Testified as an expert in several different states, several different courtrooms. Have you been qualified as an expert by those courts in those topics about which you just discussed?
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
Yes, the American Board of Pathology.
In her job, she's allowed to talk about this as a cause of death. It's not like the state licensing says, no, you can't talk about dog bites because we haven't had any courses in dog bites. So she's not limited to talk about any of this kind of stuff. Yet this court poses these artificial restrictions on her because they don't want the
puts
truth coming
forth
out.
examinations that are a 2-day examination in the various disciplines of pathology. And
Having her and Dr. Russell, I mean, what impressive
if you
experts.
successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in. And I became a diplomat in the subspecialty. Ian was elected to the
Your chin's position. What's the National Association of Allergists? Did you become of the World
Our number of associations.
Yes, when I practiced in Pennsylvania.
Have you served on any editorial boards of any
Examinal journals.
is publication?
Let's see if I death investigation and forensic pathology.
Double
I've
check
published
books.
articles involving alcohol metabolism, some drugs, cocaine, paper
Pathology, is that correct? I want to ask you,
to cause their
medical examiner,
what happens of
those 5 main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those 5 categories?
correct.
We've already heard those 5 categories.
What does it mean when the death is deemed
Scotty Bello.
undetermined?
When the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct?
Objection.
What information, what types of information does a medical examiner, forensic pathologist consider in making these determinations between natural accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those 4 sources of information, and using your training and experience, you can either say this is a natural death, this is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as undetermined. There are cases where there's just not enough information to put it in one of those other categories.
What an awesome doctor. I mean, would you dispute anything she says? She just calls it like it is. Her and Dr. Russell, wow.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed. I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death. I reviewed 100 and some photographs taken by Canton Police of the outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total, putting them in categories, did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What about Mr. O'Keefe's medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis.
She had done 50. 50 is way more than necessary. You could have just done 0 and she'd be qualified to talk about it because she's had training in it.
So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis. And then you go from that list and...
Yeah, that's a good point, Kylie Cosmos. You're saying these successful women the rest of us aspire to be. You make a mockery of what women in the workforce have been combating forever. So yeah, this isn't some old country club of men keeping these women down. This is actually a female judge, but that's what I've seen in my lifetime is that people that are appointed to positions, they didn't have to earn it. They're actually the ones that are more discriminating than the folks that normally you'll think would be the discriminators.
Pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience regarding coming to the conclusion of cause and manner of death?
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000, and then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies if you would estimate over 40 years?
Probably.
In addition to just autopsies, how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining and identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yes, and looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes.
How many times, if you had to estimate?
No, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be whatever, gunshot, something, does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, etc., that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Oh, yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like gross, grotesque, but it means like without microscopes. It means just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes,
Are you trained to do that?
absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes,
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not be so obvious on a gross examination of a body?
yes, you have to look inside the body.
And what's the mechanism of doing that?
Excuse me. We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen, and depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes.
Trying to keep this channel clean, so if you have any profanity or vile comments or else it's in your name, then I will have to remove you. So
Yes, they're usually done before the
observe that?
autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
Dr. LaPosada, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
All the time.
Have you ever taught any courses or given lectures on wound identification and wound pattern recognition?
Yes, it's part of understanding blunt force trauma, sharp force trauma, gunshot wounds. They all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
There in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for a forensic pathologist to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup contra coup injury?
Oh, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup contra coup helps the forensic pathologist differentiate that. A coup contra coup injury examines the coup, which is where the impact occurred, and then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. And that happens because the brain is floating in cerebral spinal fluid, and when the head comes down, the brain is a little bit behind, so you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra coup pattern, and that tells us that there's been a fall backwards and hitting the head.
Is that consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back?
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination, or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at injuries to the scalp, and we look at the skull, see where the skull fractures are, and in particular to look at the brain and see where the damage is to the brain. And there should, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that. And that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had massive skull fractures that started in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates
This is in front of the jury.
and fractured that, and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
You indicated that the wound pattern suggested a ridge or ledged surface. Could
Yes.
you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Dr. LaPosada, what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the coup contra coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
What would the outer, let me rephrase that.
Yeah.
What would you see around his eyes regarding ecchymosis?
Yes, when you have, when the brain slaps forcefully against the base of the skull, the delicate bones above the eye break, and that's again the coup contra coup, where the brain slaps forward. And when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids. So it kind of looks like you have black eyes, but there's not been any punch to the face. It's only come from the skull fracture. That's sometimes called raccoon eyes, because you look like a little raccoon.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustained us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe could have caused or produced the injury to the upper right eyelid.
So I'm going to see its sidebar here.
Yep. Don't want to bring out the truth once again. So that's it, folks, for
May I inquire?
Yes.
Thank you. Dr. LaPosada, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. Could be it's some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again, may we approach? This is probably a good time. We talked about it at sidebar.
Can you do anything to fill up the jury's time for the next 10 minutes and then we can do this?
Not without what we discussed at sidebar.
Come out for a minute, okay? Both of you come on up quickly.
Yeah, it surely is fascinating. It's really absolutely despicable. She cannot talk about dog bite pattern recognition. Let me see here.
I'm told that we're still on track. We will start. I'm going to have you show up a half hour later than we normally do because I expect to have 10 minutes with the lawyers, what we see sometimes with 10 minutes naturally in the course of any case can turn into. So I don't want you to be waiting as much as you've waited today. So if you take a half an hour more to get in here, whatever time you normally meet, the court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that.
Why is she so concerned with them having these sidebars and delays? She wasn't so concerned about that with the prosecution. It's like she's holding that against the defense. Coach Mo, you're saying my assessment of the juror's reaction is spot on. If HB came across overly aggressive or condescending, it's like the jury picked up on that. Might even feel sympathy for Dr. Wolfe. Yeah, that's from my experience. You cannot get away with this as a prosecutor. So I wanted to show there's a number of motions filed by both sides. There's one motion. I just want to put it up here on the screen here because it shows the degree of hiding the truth. Check this out. Unbelievable. Here's a guy, remind you of the fact that Hank Brennan said he was hired to guarantee Karen Reed gets a fair trial. So does this look like a fair trial to you? That's something also that the DA Morrissey said. This was an act of ensuring fairness, a fair trial for Karen Reed by hiring Hank Brennan. So they're trying to say that the Commonwealth has discovered several slides that contain diagrams, measurements, and further analysis concerning the injuries to Mr. O'Keefe's arm and defects in his clothing that were not previously disclosed to the Commonwealth. In addition, Dr. Rentschler now offers a new opinion comparing those injuries and defects, which was not discussed in his May 7th report. Pursuant to the court's orders, this should have been produced to Commonwealth no later than 7 May, which was the deadline for ARCA. In light of this multiple deliberate Rule 14 violations already committed by the defense. You know what? You violate Rule 14 all the time and mislead the jury on a regular basis. The specific slides at issue are 22 to 33. So they're trying to cut out that many slides. Also, they're trying to preclude the expressing opinions or conclusions that are listed on pages 6 through 8 of his May 7th report and numbered as, look at all the slide numbers. These are conclusions on the reliability or credibility of Dr. Welcher's analysis. So I'm sure it just talks about things that are not accurate in the testing of Dr. Welcher because he didn't do it to any kind of normal standards like ARCA did. So look at all this hearsay. Okay, guess what? Under his questioning, all he did was invoke hearsay all the time. And you know what? It is allowed for experts. If it's normal part of what an expert takes in to consideration and forming their expert opinion, it comes in to the trial. So that's not a basis to object. And improper bolstering, improper commentary. He's just trying to do everything he can to strike all these out. So it doesn't say whether he's wanting the entire slides or certain portions. I assume he means the entire slides. Look how many things he's trying to keep out. Well, improper opinion and commentary on the ultimate issue. Remember, he got into the ultimate issue. He got into that with his own witness. Now he's trying to keep it out. It's just such a scam. What a disgrace. Absolute disgrace. Just my brother John. We're not related to the author. So yeah, this is unbelievable. This is so unreal. You just can't make this stuff up. It's that radical. It's hard to sit here and watch it. I'd rather be there fighting it, fighting corruption, rather than sitting here having to talk about it. I can't do anything about it to fight it. So it's just very agonizing. All right, there's one other thing I was going to show. Stand by, please. Here's the defense opposition. So they're trying to say that here, defense requests the court prohibit the Commonwealth from calling Maureen Hartnett, Terry Kuhn, and Dr. James Crosby to rebut the testimony of Dr. Marie Russell. Ms. Reed further requests the court limit the scope of Dr. Judson Welcher's rebuttal testimony. To date, the defendant has received no discovery with regard to the proposed rebuttal testimony of Welcher. Wow, this was just filed June 9th. So that was today. So they don't even know what the rebuttals. Brennan's talking about discovery violations, Rule 14, discovery violations by the prosecution. So it's all I can get away with it, but I'm going to call out the defense because I've been sandbagging them. So they're saying here basically that prosecution was on notice. This is one that was denied this morning. Ms. Lewis was the one that argued it. They're basically saying that Commonwealth knew that the dog bite causation argument and evidence was already known by the prosecution, so they should not be able to sandbag and bring up Dr. Crosby on rebuttal. It's more of a sneak attack by the prosecution. They're saying the court should bar Dr. Welcher from testifying to any additional testing relating to potential injuries to the hand or arm resulting from the force of a motor vehicle collision. Yeah, they should not be able to bring out any new tests. The tests were done. And what are they going to do? Keep having tests upon tests, the battle of the tests between the experts? The judge should just shut this down. And because ARCA hasn't testified to any of these issues, such as, says here, the Commonwealth has represented Dr. Welcher may comment on Ms. Reed's Lexus key cycle counts related to text stream data, telematic data, surveillance camera data, inspection, photograph data. That's part A. Part B is presently engaged in testing to determine the forces of motion and damage associated with backing the Lexus into the rear area of a 2019 Traverse. I mean, this is all new stuff. So anyway, it doesn't matter if this court, they'll do whatever they can to bolster the prosecution. Rules are only used against the defense, not the prosecution. So yeah, but you know what? The good thing is we're getting closer to the end. The jury's sick of this case. They're sick of the prosecution. They're tired of the judge. They know it's a scam, an absolute farce. So, yeah, I think the judge's rulings, I think she's going to be heading towards a lot of botched rulings on jury instructions. Oh, that's something I wanted to show as well. Golly, I was like, you got to be kidding. I could not believe this when I saw it. Hold on a second. The jury instructions for Hank Brennan, that's the proposed jury instructions. They're unbelievable. Hold on a second. That's not it. Hold on, let me go somewhere else. Here it is. It's 709. Something jumped out at me there. Check this out. So the defense has already submitted theirs. So here they're going through the elements, the crime. Weird language like, let me help you. This is what the judge reads to the jury and says, let me help you to understand how to analyze this third prong. Really bizarre wording. Here's manslaughter instructions. They have under the influence instruction here. Leave the scene of an accident. The supplemental instructions. Use of a dangerous weapon, a motor vehicle. Use a dangerous weapon on another person, tends to kill that person. As a general rule, you're permitted, but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person. What? Or cause him grievous bodily harm or intends to do an act which under the circumstances known to him a reasonable person would know creates a plain and strong likelihood that death would result. Really? So just you can infer who intentionally uses a dangerous weapon on another person. What does that mean? Intentionally uses a dangerous weapon on another person. So a vehicle? What if you just want to bump into somebody in a parking lot? You can infer that they intended to kill that person? Wow, this is really bizarre. They talk about what is not evidence. Basically, it's all the truth that Brennan kept out with the judge's rubber stamping. Okay, then they talk about inferences, direct and indirect evidence, redacted exhibits. Look at this. This is interesting here. Witness pretrial preparation. There was testimony at trial that the attorneys interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There's nothing improper about conducting such interviews. On the contrary, attorneys are obligated to prepare for their case as thoroughly as possible and may interview witnesses. Yeah, but then look at what Brennan was doing, trying to say that they're violating the sequestration order when talking to Dr. Russell. So isn't that convenient? Then they talk about expert witnesses. That's interesting. Here, you're free to reject the testimony and opinion of such a witness in whole or in part if you determine the witness's opinion is not based on sufficient education. Why don't you just put, for example, Burgess, an experience where that testimony of the witness was motivated by some bias or interest in the case? How about $400,000 to just do a forearm rub paid on a car for the most part? Okay, then they talk about testimony photographs of emotional impact. Instructor, you must separate any emotional response from the value and weight of the evidence. Okay, that's fine. But then listen to this down here. Confessions and admissions, humane practice. You've heard testimony about a statement allegedly made by the defendant concerning the offense which is charged in this case. A statement? Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not. You may not consider any such statement in your deliberations unless, from all the evidence of the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made and that she made it freely, voluntarily, rationally. In determining whether or not a statement was made by the defendant was voluntary, you may consider all the surrounding circumstances. Oh, here it was. Yeah, that was not it. Consciousness of guilt. You have heard evidence suggesting the defendant may have intentionally tried to destroy, conceal, or falsify evidence in this case and may have intentionally attempted to harass or intimidate witnesses whom the defendant believed would testify against her. What? Where'd that come in from? We've not heard anything about that. If the Commonwealth has proved that the defendant did, you may consider what such actions indicate feelings of guilt by the defendant and whether in turn such feelings of guilt might tend to show actual guilt on these charges. Are you kidding me? When did that come out? That Karen was responsible for harassing witnesses. You're not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of the case. If you decide that such inferences are reasonable, it would be up to you to decide how much importance to give them. You should always remember there may be numerous reasons why an innocent person might do such things. Such conduct may not necessarily reflect feelings of guilt. It goes on to say you may not find the defendant guilty on such evidence alone, but you may consider in your deliberations along with other evidence. I caution you in considering such evidence that the defendant is not on trial for destruction of evidence, misleading a police investigation, or witness intimidation. You're not to consider such evidence as as a substitute for proof of guilt of the offense for which the defendant is charged. You may not find the defendant guilty on such evidence alone, but you may consider in deliberations along with other evidence. Like, where's that coming from? They submitted this to the court. So, anyway, really bizarre. What do you guys think about that? Anyway, it's after midnight here, so I'm going to go ahead and shut down. So thanks for supporting the cause here for justice for the Karen Reed defense. Recommend you guys support that. Give to their website. And I hope to be back on tomorrow night to cover more of the case. So you all have a great rest of the day or night, whichever applies. And